The difference between a small settlement and maximum compensation often comes down to what you do in the first few days following a crash. What you do immediately after a crash really makes a difference. I mean, if you have a serious injury, you want to make sure you get medical treatment that's evaluating what's going on with you, whether you have any life, permanent kind of condition that needs to be addressed. So it's important to go to the doctor right away. Obviously, many times if you have a serious injury, the ambulance is going to take you there. But we had several cases where people have refused to go to the ambulance and haven't gotten treatment right away. They thought, well, I'm not bleeding, I don't have broken bones, I'm going to get better, and didn't get better. And so they didn't go to the doctor until, 2 or 3 weeks later. What happens is the insurance company is going to claim that you weren't injured at all if you didn't go get medical treatment. So what you do immediately after the crash, if you have a problem, if you have injuries, it's really important that you get treated right away and evaluated right away.
Yeah, I absolutely agree, Tony. I always tell my clients in that first 24 hours, probably the last thing you're thinking about is your case. You're obviously suffering from injuries, things that need to be addressed from a medical standpoint. That's obviously the most important thing. But when the time comes, you're going to think about, okay, what is it that I reported at the time? Because that is going to be evaluated and analyzed by the insurance carriers, the people, and it's also going to be used at trial. So it's important to make sure everything that is reflected by or injured in the wreck is noted in your records, as that will be an important part of your case going forward. But for whatever reason, perhaps maybe what you were experiencing at the time of the wreck or immediately after, you're not there the date of the wreck, but a lot of times people are still able to go to the urgent care a day or two after. And if the honest truth is you were afflicted or you had injuries the day of, or you felt certain symptoms or things, it's important that you note that at the urgent care setting or perhaps with your primary care doctor, even if it's, 2-3 days removed from the date of the wreck.
That's right. I mean, and I think it's natural. People, when they get involved in an accident, their adrenaline's going on. They're not really certain how badly they're hurt or if they're hurt at all. And sometimes, I've oftentimes had people wake up and tell me, the day after the accident, I felt terrible. I felt like I literally got hit by a train or a truck. And the day of the scene, they felt okay, but they woke up the next day, they didn't feel well. So that's pretty normal for people to not go to the ER that day, but have real injuries. So it's important that if you do have a problem and you didn't get treatment right away, that you make sure you do go get treatment as soon as you realize that there is an ongoing problem. It's not going to get better.
Yep, absolutely agree.
John, when people go to the emergency room, there's typically a lot of different providers that see them. There's radiologists, there's ER doctors, and other bills that come along with that. What can you share with people about those issues?
Yeah, it's a good question. A couple things I can share that's absolutely true. And, obviously when our clients come to us, they're starting to get these bills in the mail. And when a motor vehicle wreck's involved, there's going to be multiple payers and there's a lot of confusion. One joke I always make is that medical billing currently in the United States, in my opinion, is kind of the Wild West. So first off, I try to ease my clients' nerves on, look, this is going to get sorted out. Obviously, don't be worried about the billing that you're going to get in the first 90 days because it could look a lot different as you get those subsequent follow-up visits. And there are certain things that the client can do that a lawyer can help them with to make sure that the billing is handled appropriately. And those things have to do with, obviously, medical payments coverage that they have available to them under their own automobile insurance policy. You identify whether it's a workers' compensation claim, were they on the job, and that's an avenue to get the bills paid, but also their health plan and those sorts of things. Because as we know, Tony, when you have a liability case against an at-fault driver or company, they're not going to pay those bills in the short term. That's what their clients hiring us for, and that process is going to take a long time. And I've heard you say this to clients a lot. You say, I want your bills in the short term to get paid as if you had no case. So you'd say, okay, well, if I didn't have a case and I didn't have to hire John and Tony to pursue my case, how would I get these bills paid? And you look to those things that I said. So, I'll speak to that. What do you think about that?
Well, I think that you're exactly right. And one thing to remember, and people think initially, oh, that guy ran a red light, so he's the one that should be paying my bills.
Right.
That's not really how it works, because at the time of the crash, when you go get treatment from a doctor, the other side's not responsible until either a judge or a jury says they're responsible or they agree to be responsible. And when you're involved in a case, they're not going to agree to be responsible until you're willing to sign on the dotted line and settle your case in its entirety. So the only person responsible for your bills initially is you, because the doctors didn't provide care to the other driver, they provided care to you, and so you're responsible for those bills. So that's right. When you said earlier, what would I tell people if they didn't have a case? What would they do? I tell people, what would happen if these injuries happened because you hit a deer or you fell asleep at the wheel and hit a telephone pole? What would you do? We'd use all the bills and all the insurance you have available to you, whether it's your own auto insurance, whether it's your health insurance, and we'll make sure you get those bills paid with the resources and coverage that's available to you now. After you get that done, you make sure your creditors aren't messing with you, your credit's not getting jacked up and messed up, then we can focus on getting that settlement from the other driver.
Yeah, we've always told clients, you focus on healing, let us focus on the recovery. And the benefit you get, not just with our law firm, but with all other law firms, is that there is a lot of paperwork involved. There's a lot of coordination. And once you have a competent lawyer, and what we do for our clients here at Parr is we're going to be able to navigate getting those claims open, getting that medical payments coverage claim with your auto insurance, because under some circumstances, that is the primary payer. And some health plans are going to want that money to be exhausted or paid out first to the providers. And oftentimes that could be a small amount, 5 or 10,000. And then they create an exhaust letter that we help provide that to the health plan, who will then start paying claims. It's funny because more and more people are so and justifiably worried about their credit. And I've learned some new things about, when bills go into collections, those sorts of things. And I don't think it's as quick or as soon as people think. Sometimes it's, it's not even going to go to a collection agency until a year after the service has been provided. And oftentimes I hear they're not even submitting to the credit agencies past due or unpaid bills that are more than $500. So oftentimes, by that 1 year out mark from the treatment, we've already sorted through the medical payments coverage, coordination with perhaps Medicare, Medicaid, our clients' health plans, and that's all been sorted out. But again, that's something very difficult for clients or families to do on their own. And that's a great benefit in addition to having your lawyer. What you're really hiring them for is to pursue the liability case against the at-fault people, is to help them as part of our service with those medical bills and getting all that sorted out.
Yeah, and sometimes it's hard for people to come forward with the idea that, wait a second, the other driver caused the accident. Why should my insurance company pay for any of this? I understand that concept because we have an idea that whoever's at fault should be responsible, because Indiana is an at-fault state, right? However, what we can do is, if we use that auto insurance of yours, if we use the health insurance, it's important to know that that is your coverage, but on the other end of the case, they get paid back, they get reimbursed. The benefit, though, of using your own insurance coverage now, whether it be auto or medical, is your bills get paid now, and you don't have to be in a hurry to settle your case with the other driver. You have the ability then to take your time to make sure your claim is fully evaluated and you get full compensation. If you don't use your own health insurance company, or you don't use your own auto coverage to pay those bills in the meantime, sometimes people feel the pressure and the stress of the finances coming down on them with these unpaid medical bills and all that. If you have the auto insurance, if you have the health insurance, use those now so you don't have to worry about these bills being unpaid. And don't worry about your insurance company. They get reimbursed on the other end of the case. So they're going to be taken care of, and that's part of the policy that you paid for and you bought.
I think what you're saying is we'll help with getting it paid in the short term, and the client will be money ahead by using those avenues that should pay, that are obligated to pay, and it will all work out in the long run. And, there's oftentimes, Tony, that, and you know this, that we get unpaid, for example, perhaps the client had to be airlifted or something like that. There's a very large bill that doesn't go to a lawsuit, but just remains as a balance throughout our course of our representation in the case. Oftentimes, when the client is ready to settle, or we do get a recovery through trial, we are, through some of our methods and negotiation tactics, able to negotiate those owed balances way down, which results in more compensation for our clients. Tony's jumping in here. Sometimes clients talk about, or we need to know about, evidence collection, photographs, those sorts of things, whether it's the injuries, the vehicles involved. What are your thoughts on that?
Well, it's important to document what's going on. Usually the police officers will document the scene with photographs, but that's not always the case. And sometimes they don't photograph the things that are important to us. So it's important that if there's anything that you think is unique to your case, that you photograph that, whether it's a vehicle or whether it's a scene of the accident, and gather whatever you can. On your injuries, though, it's really important to make sure that you document what those injuries might be. I know the records are going to reflect what your injuries are, but many times people will have, bruises, they'll have cuts, they'll have scars or whatever it may be. And, it's important to photograph those things because, when we talk about a case and we are in the future, let's say we're 6 months down the road and we're trying to navigate the resolution of the case, trying to talk about getting it resolved. Many times those things have healed, and it's difficult to prove those injuries if we don't have them documented. So take photographs of the bruises, take photographs of the road rash, take photographs of those things so you can document those problems. So if we need those in the future with the insurance company, it can add some authentication and proof to those injuries.
I do want to transition here about journals and journaling, what's discoverable, and advice that we give to our clients on pain journals for purposes of a case and being able to prove a case. I'll start off with you, Tony. What kind of advice do you give your clients on pain journals or documenting what the recovery process is?
Yeah, I mean, typically things that clients share with us directly, correspondence to us, is protected by attorney-client privilege. But if they're simply taking a log and making a journal, it's important to make sure that they know that whatever they journal in there, for the most part, is going to be discoverable by the other side. They're going to read it. So
Right.
I tell people, if you're going to write something down, make sure you write things down that you would not have a problem with the other side seeing, whether it be the insurance company, the other lawyer, or the jury to see.
Yeah.
So if you're going to document these ongoing problems, it's good because you may forget some of the impacts you had later, because there may be a point we have to explain, how did this impact your life? How did this affect you? And it's important to document those things, but make sure you document kind of just the facts, ma'am. I mean, document the things that you would feel comfortable and important to your case, because whatever you document is going to be discoverable by the other side.
That's right. The only other thing I have to add to that, Tony, is you got to keep in mind and let the client know. And as he said, if we're asking the client to do it for purposes of assisting us in a representation, most oftentimes, and certainly I would argue, that's not discoverable by the other side. If it is discoverable, I can tell you one thing that the insurance companies and the defense lawyers are going to do is they're going to take that journal that was created and they're going to match it up with the medical record. So I always, talk to the clients, and we've talked about this before, about making sure that you're not underreporting to your providers. Obviously, don't embellish or create something that doesn't exist, but oftentimes we want to go into our providers and perhaps paint a rosier picture of how we're doing than what the reality is. And that's not well served for purposes of your case. You're going to note all the parts of your body that are still in pain or you're having problems with. But going back to the pain journal or any journal that's created, just keep in mind those that are going to review it or have the ability to review it, they're going to size up those two things. They're going to look at the medical records in combination with what you reported and what you spoke to your medical providers about when you got your treatment.
Yeah, most of the time it's not a problem, because as long as you're consistent and honest, it's not going to be a problem. But it's important, if you document those things, just make sure you're accurate and you're full and complete.
Tony, one thing, sometimes we talked about when we get hired at all time frames from when the injury or the wreck occurred. And a lot of times what we hear is that the client, as the injury victim's already been contacted by the insurance company. And we're talking just days, a week after the wreck. And there's been some kind of hybrid offer that we'll pay your ER bill and we'll offer you $1,000 for pain and suffering. What trap could that pose for our clients?
Yeah, that's a real problem, because many times people are involved in an accident. They've got medical bills coming in, they've got lost wages, and unfortunately the bills don't stop. Your credit card bills still come in. You got to buy groceries, your kids need things for school. So you have a pressing need for money, especially whenever you just added on these additional expenses. So there's a pressure to try to get the case resolved quickly, but there's also a big problem with that. When you have a case in which you try to resolve it quickly, the problem is many times you don't really know what the full picture of your injuries and damages are. You may have a situation where you have a knee problem, for example, and you're going to need knee replacement in the future or additional treatment. Or sometimes you don't even know what the injury is exactly. You may have a sore back, but you're not sure what it is. If you settle the case early, they're going to require you to sign on the dotted line. And once you do that and you accept the settlement, let's say you go back to the doctor and they find out you have a herniated disc, and now you need to have an injection or you need surgery or treatment. You can't reopen your case, and that's a real problem. And I can tell you, I can count a lot of times when people have come to me and said, I've settled the case with the insurance company. Here's a release I signed. Can you get me out of this? Can I get more compensation because this didn't reflect what's going on? I found about new problems later. And the answer is typically no. I mean, once you agree to that settlement, that's going to be binding. Courts favor resolution of cases. And if you settle the case with the insurance company and sign a release, you're typically bound by that release. So make sure before you do that you know exactly what your future plans are, what your future injuries are. If you have to miss work, if you're going to miss work in the future, you have that evaluated. If you're going to need future treatment, you have that evaluated. So you don't want to settle the case until you know where you are. And that's usually what's called maximum medical improvement. And it could be that you've reached maximum medical improvement and you're back to normal or baseline, which is fantastic. Or it could be that kind of what we see is what we get. And we know you have a bad leg or we know you have a bad back, but that's something you're simply going to have to live with. Once you've reached that maximum medical improvement, we can go through the process of evaluating what your damages are long term and make sure that any settlement includes all the damage that you suffered, not just the ones that you've suffered up to the time of that release, because that's what they're typically doing, is only paying you for what you've suffered so far. And until you know what the future holds, it's impossible to reach a settlement that includes all the things, including the future.
Yeah, and that's well said, Tony. My thought on that, and I say it to my clients, but at the end of the day, when you are negotiating a liability claim, a personal injury claim, what does the other side really want? Well, they're trying to buy your peace, and Tony talked about the release. They're trying to buy your peace, and they're trying to say, okay, we will compensate you for what you've been through, and in exchange for that, you'll sign this release, which forever bars you from suing our insured or suing our client, or you have to drop your lawsuit. But that's it. And we talk about it's the one bite at the apple. And that bucket of what we are trying to get compensation for our clients, that encompasses all of the legal damages for which our clients can go to a jury and ask to be compensated for. So what does that include? Well, it includes medical bills, includes time off work, includes physical pain and emotional suffering that has already been suffered from and incurred. But what does it also include? It includes, in what you would sign in the release, is future medical expenses, future lost wages, future pain and suffering. So again, it's very important that when you do get to the point where it makes sense for your particular case to resolve it, that all of those damages that have been suffered from or could be suffered from in the future have been included in that offer or that settlement amount.
Yeah, that's a great point, John. And one thing to remember is people sometimes they feel powerless when they're involved in an accident and they're dealing with the insurance company. They think, my gosh, they've got all the power. It's a big insurance company. They've got the money, they've got the power and all that. But that's not necessarily true. You have a lot of leverage as well. As an accident victim, you have something they badly want, and that's a release.
Right.
And so they want to make sure that the only person that can let them out of the case is you. And so it's important to make sure before you sign that release that you make sure all of the terms are understood. And it's important you make sure that this release covers what you're really entitled to. And until they do that, you're not going to sign that release. If you're dealing with an insurance company and need help protecting your rights, call us at 317-269-2509 for a free case evaluation.